Welcome to this sixth episode of the Binary Agora. In this series, we dive deep into the world of legal tech, breaking down its challenges, its innovations, and real world impact with insights from top researchers. Today, we'll be discussing especially AI partnerships and also how flexible are antitrust tools to try to capture them effectively. To do that, we have with us today Teodora Groza, a PhD student and also lecturer at Sciences Po. She's also going to defend her thesis in a couple of days now, so congratulations on that. And she's also a research fellow for the Track AI project, an initiative also co-hosted by Sciences Po Law School and Codex. She's also one of the most encouragingly active scholars in regards to computational antitrust and also the dynamics of AI. So it's a pleasure to have you here.
It's a pleasure to join you, Alba, and thank you so much for the invitation. It's a great opportunity for me to get the chance to talk about a bit of the work I've done as part of my PhD, but also as part of the Track AI project. And before I start, I want to take the chance to highlight the fact that this work has been done by a team of amazing research assistants working both on the software side. So we have Alex Mack, who has not only helped us build computational tools, but has also taken the time to explain to the legal team how AI actually works. And as you will see during my presentation, these insights have been really crucial to our understanding of the legal implications of AI. And also we've had an amazing team of legal research assistants who have done really great work on unpacking the intricacies of EU merger control regulations, case law, and so on. So before I delve into the computational aspects, I want to take a step back and start by discussing the role that AI plays in our current economy. And to get there, I want to begin by framing AI as a type of infrastructure. So the question is, what does it take to run a business? Alba, do you have anything in mind in particular that really enables the economy to function?
Having done my PhD on data protection and competition law, I would say that you need data. So data as maybe the oil of the digital economy, particularly.
Yes, exactly. So data is a key asset. But if we take a step back and we look a bit back in time, we have more physical things like roads, electricity grids, water pipelines, and so on. And as you say, in current days, we have the internet and data. And if we look at how things are looking in the economy today, what we see is that AI is actually also becoming an infrastructure. And to back this up with data, recent surveys show that almost 50% of large enterprises deploy AI in their day-to-day operations. Out of all the business owners, 97% think that AI actually benefits their operations. And if we switch this discussion to the more specific ecosystem of startups, we see that about 9 out of 10 startup founders actually rely specifically on one of OpenAI's foundation models, GPT, so GPT-4, GPT-3, and so on. And then if we want to look at how AI is actually used in terms of concrete use cases, it's used for customer relationship management, content production. But interestingly, it also plays a role in more traditional business functions like inventory management, accounting, or supply chain operations. So all this to say that AI is basically everywhere, not only in the tech-intensive AI-native startups, but also in the classic brick and mortar stores, and even businesses like postal services leverage AI in their day-to-day operations.
I was also thinking within the previous that every single company is also adding on AI regardless of their offerings. So especially from a user perspective, it seems that AI is also going to be integrated into every single service, no matter whether it also adds value or not.
We see two phenomena. One of them is the fact that, as you say, you have AI applications integrated in any business. So even if you go to an e-commerce website and you want to buy shoes, you'll get a pop-up window saying that, hey, I'm your AI assistant, do you need any help? Even if you don't actually need the help because you know what you want to buy. But also more interestingly, we do not have any data on how the employees of these businesses use the AI themselves, right? And you have people who use ChatGPT to write emails, schedule meetings, and so on. And this actually also plays a role to strengthen the idea that AI is basically absolutely everywhere, right? So we are on the same page here that AI is becoming the infrastructure of today's businesses. But why is that important? And what we have argued as part of the Track AI project team is that AI is not any type of infrastructure, but it's specific in the sense that it's self-improving. Now, if I say self-improving, you probably have in mind something completely dystopian, like, AI grows itself by itself. It's not really what I mean. What I mean is to think of, for instance, a highway that gets better and bigger as more and more cars run on it. which is actually the opposite of what happens in real life. Because if you have a highway and cars are using it, it deteriorates. It starts to develop holes, the road is not so smooth anymore, and so on. But with AI, we have the opposite dynamic. So the more foundation models are being used by developers, the more they have access to more data. This data is then used to better train the models, and the models get more performant, which of course then means that they get adopted more and more by developers. And this dynamic is actually enhanced by the fact that foundation model developers like OpenAI, for instance, often collaborate with data-rich businesses in order to get more data. Like, for instance, we have the collaboration between OpenAI and LexisNexis, which was used to enable LexisNexis to develop AI assistants tailored for the legal tech industry, but has also benefited OpenAI because OpenAI itself needs better insights into the legal industry and into legal knowledge. Now, the question is, what are the risks that stem from the fact that AI is self-improving infrastructure? And what we observe is that this infrastructure actually comes with the risks of new forms of economic exclusion. So because access to foundation models and to AI applications becomes synonymous with being able to compete effectively, since AI is so pervasive in all types of business operations, not having access to AI systems can lead to actually being cut out from the market because you cannot compete as well as your peers, and because you'll be lagging behind so much that customers will never want to actually tap into your products. And the problem is that unequal access can take a specific form where data-rich businesses like LexisNexis, for instance, or Salesforce can have preferential access to foundation models because they have something to offer themselves to the foundation model developers, right? When you have win-win situations, of course, that access will be granted. But when the customers of foundation models do not have as much data to provide in exchange, you can have more restrictive licensing. And on top of that, there's the issue of barriers to entry. Since existing models are getting better the more they are used, and they are getting more fine-tuned and more able to capture new types of customers and to tap into niche markets, entry on the market will actually get more and more difficult. Lastly, and this is something also that's specific to AI as infrastructure, it's the fact that this infrastructure is developed so far by private companies. We do not have any state-backed foundation model that businesses could use. It's all developed by companies which are at least partly for profit. And we have, of course, outliers like OpenAI and Anthropic, who claim that their mission is to promote the interests of humanity at large. But even these companies still have a for-profit branch or a for-profit component to their operations. And this means that their developers have as their main interest to maximize profits and not necessarily to develop safe models. And this can lead to clashes between our long-term interest as a society and their short-term interest in developing profits. And then the question is, how can we internalize all these externalities? So then the question is, we have all these potential problems, we have this dynamic that we haven't seen before. What can we as lawyers or regulators do? Alba, what would you do as the first thing if you could?
That's a really hard question, especially because regulators and also competition authorities really have identified these problems that you have also outlined already, but they are not really sure whether merger regulation should be applied, or whether Article 101 should be applied, or whether it's also necessary or even proportionate to apply regulations such as, for instance, the Digital Markets Act and the Digital Services Act, especially on the side of the safety aspects that you were mentioning. I would say that maybe some sort of capturing via merger control, but I also believe that you're going to explain to us that it's going to be a bit tricky to work out for the competition authorities.
Yeah, so that's a great answer because you really highlighted the first entry point of regulators into this landscape, which has been really merger control, right? Specifically to the web of partnerships between big tech firms and AI companies. These partnerships are really a trend that pervades the whole AI industry. There's this really beautiful graph made by the French Competition Authority where they map out the fact that basically every single AI firm known to the public at large, so OpenAI, Anthropic, Inflection, DeepMind, and so on, these are all firms which have ties with big tech companies. And these ties take various forms, from more basic relationships where big tech supplies computing power to more complicated dynamics where it's not only providing computing power, but also giving access to data or actually investments, IP licenses, and so on. So the question then is, what can competition authorities do to intervene in these partnerships? And so far, the main point of legal intervention has been merger control. I've seen investigations carried out by the Bundeskartellamt, by the European Commission, by the CMA. The FTC also has issued requests for information but has not started any proceedings. And the poster child of these investigations has always been the OpenAI Microsoft partnership for several reasons. One, the fact that this relationship is particularly complicated because of OpenAI's corporate structure, in the sense that Microsoft owns 49% of OpenAI's for-profit arm, but doesn't have any sort of legal control rights over OpenAI's governance. Of course, on paper. Because if you remember what happened in November 2023, when there was this whole governance scandal at OpenAI and Sam Altman was ousted by the board, it so happened that Microsoft may have played a very important role in putting him back, which of course puts into question the whole dynamic of whether the lack of governance rights on paper means the lack of governance rights in practice. Now, why did competition authorities rely on merger control? Why do you think this was the default approach?
I would say maybe they relied on this because it was the easier way to try to capture it, especially in terms of speed. The generations of services are launched to the public within a short time span. Also motivates the fact that maybe competition authorities wanted to do something, and merger control was the fastest way to do that.
Merger control was chosen as the default, as the legal hook to tackle these partnerships for several reasons. The main reason, I think, is the fact that these relationships seem to have bilateral implications first and foremost. So what the authorities were concerned with primarily was whether OpenAI remains independent as a market actor or whether Microsoft actually controls it. But also something interesting is the fact that merger control was used as a tool to get more information into how the partnerships are structured. And I've been at a conference last year where a CMA representative actually said that they launched the investigation primarily as a means to get more data onto how the deal is structured, because the public at large has very limited visibility into how the relationship actually plays out legally, but also in practice.
Requesting information may also trigger a related consequence for the competition authorities, which is, okay, we have all of this information available to us, and now we must decide whether the conditions and the facts of the case really fit in within the merger control regime, right?
Yes, exactly. And this is really what happened. So after looking into the relationships with the additional data they gathered through the merger control investigations, all of the authorities realized that it's actually not a merger, because what's at stake is not conferring control. And then this points out to several issues. First, the fact that merger control doesn't play any role when you cannot prove that one business controls another one in the EU. And second, the fact that if you cannot prove control, even if the deal actually has systemic effects on the market, merger control will not take you anywhere, right? As soon as you cannot prove that OpenAI is controlled by Microsoft, merger control will not give you any rights to look into what this relationship provokes on the market in terms of wider effects that may affect other businesses too. OpenAI can operate independently, but to what extent can they partner with, let's say, Amazon to get computing power, right? Would Microsoft be happy with that? And then the answer would most likely be no, because as we've seen based on how the relationship evolved between the two companies, OpenAI kept asking for more and more computing power. Microsoft was, of course, unhappy about it. And because Microsoft wanted to keep its control over who gets to supply OpenAI with computing power, today the relationship looks a bit different in the sense that Microsoft is no longer the exclusive supplier, but they have a right of first refusal, meaning that whenever OpenAI wants more computing power, they have to go to Microsoft first to ask if they cannot provide them with the additional compute. And only if Microsoft says no, can they go to competing providers. And of course, this can create competition problems, but it also asks the question of what do we do now? So we cannot use merger control, but what other tools do we have available to actually tackle the systemic effects of AI partnerships? And my research so far has focused only on merger control, but with the Track AI team, we're looking right now into other potential avenues. And something interesting to look into would be, in my opinion, public utility regulation. And this ties back nicely to our discussion at the beginning about how AI is infrastructure. And then the question is, to what extent can we qualify foundation models as infrastructures or public utilities? And to what extent could we impose universal service obligations on these services to make sure that access to these foundation models is fair and equitable and doesn't effectively cut out any small businesses from the market? But I'm also curious to hear what you, Alba, think could be done, especially given your extensive work on the DMA, of which I know almost nothing. The DMA came out at the
Yeah.
time when I had just started to look into AI partnerships and the dynamics of this market. And I thought, okay, I cannot play on both battlegrounds. And this is a very nice division of labor.
Yeah. Agree. So on the DMA front, and I also came back from the FIDE conference, and they were discussing especially the risks that AI poses for the future and also for the present of how digital markets are going to be shaped. We have a problem within the DMA that if the gatekeeper does not cater what we call a core platform service, then you cannot be designated as a regulatory target within the DMA. Generative AI services or AI in general are not included within that list of core platform services. At face value, we cannot capture AI directly via these means. However, the fastest way to try to curb the power of these big tech or big AI partnerships was proposed to, on one side, maybe amend the DMA by adding on this list or by classifying and by designating existing services under the existing categories, namely virtual assistants or search engines. For instance, OpenAI can also be maybe classified as an existing search engine, and then all of the DMA obligations would kick in. For instance, Article 6.5, which also imposes the self-referencing prohibition, or some more conflictive provisions would also apply, such as Article 5.2, which is the prohibition of combining cross-using personal data across core platform services. And for instance, with Google, it could not combine the data that is coming from its advertising model back to its LLM, because then they would be classified as two different core platform services. So I would say the DMA is the best option or the best path that we can really take. But also going back to your points on the barriers to entry and also the economic effects that are maybe distinctive to AI, we must first identify them carefully, because the DMA is really pervasive in its effects because it applies en bloc.
So I really like that you raised this point because this actually goes to the core of my PhD research. So what I observe in my PhD is that actually competition law has a very crude understanding of how market structures work, in the sense that it only perceives collaboration between firms as taking the form of either a merger, so one firm gets control over the other, or potentially a cartel, where you're doing activities which are competitively problematic, and then your agreement is considered to be infringing the market competition, and you analyze whether this agreement has redeeming benefits. But actually, what we notice with AI, and we've been noticing with highly innovative industries since the 1970s, so biotech, even in construction, we see these mechanisms, is that firms are actually enmeshed in collaborative structures which are neither merger nor cartels, in the sense that these firms don't have just agreements to collaborate, but they also transfer some forms of governance rights. And if you look at OpenAI and Microsoft, of course, we don't have governance rights on paper, but the fact that the company's engineers collaborate closely, the fact that one company actually was involved in the other company's leadership scandals and so on, shows us that this agreement is not just a market contract where they exchange inputs and outputs, but it's actually a hybrid collaboration where they are way closer than market competitors, but they're not merged because they still remain independent in their own operations. And then the question is, what do competition authorities do? And I think that applying both merger control and Article 101 is too restrictive and fails to implement the learnings of IO economics, which actually shows us that hybrids come with their own benefits, in the sense that they are, one, very adaptable, they are pro-innovation, and they are also sometimes an effective merger control tool, because if companies can collaborate without merging and they don't face the risk of Article 101 liability, then they may be less incentivized to merge. Now, the question is, if we don't apply neither 101 nor merger control, what are we left with? And the answer is, I don't know, because such a tool doesn't exist, right?
But it's not only that you don't know, but the competition authorities also don't really know how to capture AI And I believe maybe some sort of coordination is going to maybe emerge between these competition authorities in trying to exchange information and also economic evidence on how these markets work to try to maybe nail down the problem a bit further.
But I think that the first step is to realize that collaboration is a new type of market structure alongside competition, which comes with its own risks and benefits. But that its analysis should not start from the premise, which is the default today, that collaboration is bad and competition is good. And for that, luckily, we have lots of IO economics to explain us how to assess these collaborations. But we really need to move past the current dogma that competition should always be the norm, because what we see with AI and with the fact that basically all products that are household AI products today are the product of collaborations teaches us that it may be a necessity in some industries. So we'll see where the competition authorities take it from here.
With that statement, I believe that maybe we can wrap it up. Thank you so much, Teodora, for the insightful and maybe provocative thoughts on how to tackle all of these non-mergers within the digital space. And for anyone in the audience that has any questions, just drop a comment below. So thank you so much, Teodora, for joining us, and also looking forward to maybe meet in some academic venue soon.
Thanks for having me, Alba, and yes, hopefully see you soon.